All right. Good afternoon, everyone. And thanks for joining our webinar, The Changing or Evolving Reasonable Consumer Standard, which is the next in our series of our brown bag lunches that we're doing and that we've recently started. We are very happy that you have joined us here today. If you experience any technical difficulties, feel free to type in the chat. And we'll see if we can get those fixed. And first of all, let me introduce myself. I'm Trent Taylor. I am in the Richmond office. I'm co-chair of our consumer products and retail team. I do a lot of consumer class actions as well as regulatory work. And I'm joined by Frank Talbot, who I work with frequently and is one of our star senior associates. Does a fantastic job and has defended a number of his consumer class actions on his own and has gotten fantastic results. So delighted to have Frank with us here today to share his expertise as well. And what we're going to do today is we are going to talk about the reasonable consumer standard, as you might have deduced, and mostly in the consumer class action context. We're going to start with maybe historically what it has been, some recent developments, where things stand now, and then some practical takeaways. And if we have time, we may also go into consumer surveys to a certain extent. So let's jump in. And we're going to start with what is the reasonable consumer standard? And that seems like a pretty easy question, but it has flummoxed courts for a while. And, there are a number of states that apply some version of the reasonable consumer standard or test to false advertising claims. One sort of general definition is that it's meant to be objective, and it has courts asking whether an advertisement would mislead an objectively reasonable consumer, and not whether the actual plaintiff was or was not misled. Now, a related definition that I've seen in some cases, and this is taken directly from a Ninth Circuit case in 2016, is it has been defined as the probability that a significant portion of the general consuming public or of targeted consumers, and that matters, I think, acting reasonably in the circumstances are deceived. So we'll go into that in a little more detail, and we're going to jump in here in just a second. But one of the things I did want to flag up front is one of the frames that we're going to be using is The Simpsons. So I'm a big fan of The Simpsons. I've been watching it for a long time. My kids watch it. And if you know me, you know that I will frequently quote it. And so we're going to be using that as one of our frames today and try to have a little bit of fun with this. But before we jump in, let me turn to Frank real quick and ask Frank, do you have a favorite Simpsons character?
I don't know if I have a favorite, but I have one that I identify with more than others, and that's Principal Skinner, since he is always dealing with antics from young kids and Bart Simpson and seemingly getting constantly run around by the kids. And I have 3 young ones at home. 2 are school age, kindergarten and second grade. And I feel like they have the intelligence of Lisa and the proclivity for pranks like Bart. So kind of a lethal combination at home sometimes.
Nice. Okay, fantastic. Okay, so we're going to jump into the historical standard for the reasonable consumer. And this goes back, and I know this is a case recently from the Ninth Circuit just less than a year ago, but in particular, what I wanted to flag is what is in red here, which quotes a 1951 Ninth Circuit case with their interpretation of the FDCA. And it talks about protecting the ignorant, the unthinking, the credulous consumer. And so going way back, I think there was an idea of attempting to protect the lowest common denominator of consumer. So, not necessarily the reasonable consumer, but, you know, even if a consumer is not the sharpest knife in the drawer or sharpest tool in the shed, as the case may be, they would still be protected. So I think that's important to know. That's sort of where it started. And here is a more recent description of it. And so this is actually from a California state court case, quoting another California state court case. And it says the reasonable consumer standard is evaluated from the perspective of the ordinary consumer within the larger population who is not typically exceptionally acute or sophisticated or wary and suspicious of advertising claims. And that last point, I think, is an important one, even though I didn't highlight it, is being wary and suspicious of advertising claims. So it almost treats it as someone who goes into a supermarket for the first time, has never dealt with claims and labels before, and they see something and they're like, oh, geez, I thought it was X. When we know, just from personal experience, that most of us, we go in and we shop a lot. We shop, all the time at the grocery store or somewhere else. And we're constantly exposed to marketing, right? Whether it's TV, radio, online. And we've been around the block a little bit. So I think it's important to know that, prior to some recent events that we'll talk about, the reasonable consumer was someone who was not wary and suspicious of advertising claims. All right, and at this point, I'm going to turn it over to Frank to go through some I think, examples that exemplify sort of where we've been.
Yeah, thank you, Trent. And so, sort of picking up on Trent's last point about being around the block, there have been cases that, and some of them that we'll discuss in here, that note that consumers understand that businesses are advertising to sell products. And so there is this like base understanding that like we understand they're trying to get us to buy the products, and it shouldn't be looked at in like a complete vacuum. But some of these past examples we have, the Pope case, Silver, and Boschnack are just a couple of them where these cases have been dismissed, and many of them call them puffery. For example, the Silver saying that our hydration drinks provide superior hydration isn't deceptive because it's just puffery. It's trying to pump up their product. But so sometimes the courts will be relying on that, but and being a little wary of the older view of the reasonable consumer being, as Trent put it, the lowest common denominator. So that's great, but it's still a mixed bag. Healthy Halo claims have recently been certified related to 31 cereals, and the Halo claims relating to sugar content. So there are, while there are positive trends, there's still some downside. And it's important to note that even in California state court, where defendants might have a tougher time, are tacking towards this trend. And I'd just like to highlight sort of the last bolded part here, where the court said that the reasonable consumer is unlikely to make the required series of inferential leaps to be deceived, and that allowing such a theory would make litigation fodder out of almost any advertisement. Again, it sort of goes to the point that there are limits, and you can't just look at this stuff in a vacuum and not consider what normal people on the street understand. So again, good thing that what can be perceived as a tougher courts are recognizing that all of these inferential leaps would literally let any advertisement be subject to a deceptive advertising claim. And a good case that sort of highlights the consumer context and like where the consumer is when they're making these purchases and being exposed to these advertisements is, or being exposed to advertisements and information is the Killeen versus McDonald's case, where the court dismissed a class action alleging that defendant misrepresented that purchasing bundled value meals would cost less than buying each of the meal items separately. And the court said, where consumers have access to that information that allegedly caused the misleading marketing, there's no possibility for deception. And it's important here, would assume that most everyone here has been to a fast food restaurant, and including a McDonald's. And as you know, you're standing in line and you look up and you see the menus and it has the prices. And so the court says, like, look, if you just look up and see, like, you can do a little bit of deduction that, to understand that the extra value meal, the pricing related to that, those individual items. And so again, the context of how the consumer is interacting with the ad and the information is important to understand. Similar issues related to diet claims. One of these examples is the Becerra case that dismissed the suit claiming that Dr. Pepper falsely advertised Diet Dr. Pepper as helping with weight loss. And the court said it's not plausible that reasonable consumers would believe consuming Diet Dr. Pepper leads to weight loss or healthy weight management absent a change in lifestyle. Again, noting that diet soft drinks are common in the marketplace. It goes back to everyone kind of understands that being healthy and losing weight isn't just one thing. It is a combination of things, and the Diet Dr. Pepper is just a small sliver of it. And it's unreasonable to think that the reasonable consumer would believe that simply switching from Dr. Pepper to Diet Dr. Pepper would lead to weight loss and the results. Same relates to slack fill cases. This Daniel versus Tootsie Roll Industries case is the court kind of showed through how frustrating it was having to deal with the claims of slack fill being deceptive. The court declines to enshrine in the law an embarrassing level of mathematical illiteracy. When a court calls a theory embarrassing, it kind of shows how tired it is of having to deal with these sort of cases. And we saw tons of slack fill cases, and they've trickled down significantly. And a lot of that is based on these sort of decisions that it's like, we're not going to get to the lowest common denominator as the reasonable consumer. People understand in their regular lives how things work, and we're not going to we're just not going to allow you to proceed on suits like this.
And Frank, I just want to jump in real quick, but that Tootsie Roll one is one of my favorites, just because it is an example, as you mentioned, of where the court shows its frustration. And I think there's some other examples of those as well. And sometimes courts are better at sort of not showing it and not necessarily using as strong a language as we see here. But you can tell that the court has become frustrated with some of the claims that are being made. And you're going to see that in the next slide that Frank's going to go through as well. It's very welcome, because I think at one time the judges would sort of let these go through and say, yeah, it's up to the fact finder, it's plausible, that kind of thing. But we're seeing courts increasingly, and we have seen it over the last 5-7 years, who, especially with courts and judges who have seen a number of these, such as in California, get frustrated with the plaintiff's counsel and with the types of claims that are being made, and going ahead and kicking them at the motion to dismiss stage. So sorry, go ahead, Frank.
Yeah. No, that's a great point, and you'll see as we go through, a lot of these are California Ninth Circuit, and New York, and some Illinois cases, and so that's where a lot of these come from, and and getting to the point about the these Starbucks cases where the plaintiffs allege that basically I ordered a 12-ounce drink, I expect 12 ounces of liquid in it. The court kicked it again because no reasonable consumer would think that you purchase a 12-ounce ice drink at a Starbucks and there wouldn't be ice in it. And that's also not just related to Starbucks alone. It goes across all. It goes across all sort of retailers selling beverages. Like that's what happens. You order. I took my kids to Chick-fil-A after ballet last night. Ordered them lemonades. Like, of course, there's going to be ice in the kids' lemonades. I wouldn't think that the small lemonade would contain the like 8 to 10 ounces. Like it's got ice in it because that's what everyone does. And so that's what the normal, reasonable consuming public experiences every day in countless transactions and countless purchases. So we're not going to allow you to try and get by on these theories that are just really not plausible at all.
Yeah, and just the second that, I mean, it's not the court. In order to actually have this be a plausible claim, it would have to be, for instance, my 14-year-old son who walks into a Starbucks and orders maybe his first iced coffee or his first latte ever, who's never had one at all, and then it's like, oh my God, has foam in it. And that's just not something that a lot of courts are willing to do much anymore. That it's someone who has had a latte before. They know that lattes inherently have milk foam, and that folks are going to expect there to be some level of milk foam in the coffee. Sorry, Frank, go ahead.
Yep. So, and it's not just related to pricing or like the contents of the product. Ben and Jerry's beat Happy Cow's suit. Ben and Jerry's advertises their ice cream as coming from Happy Cows, and it's based on their social and environmental assessment reports, and they provide that information on the website, on the web page. But here, the court dismissed it, basically saying, right, a reasonable consumer shouldn't be required to search for the information. Say, for example, if the website said it came from Happy Cows and then made the consumer click through 10 or 12 hyperlinks and go down a rabbit hole to find out what they really mean by Happy Cows. Here it says, in this case, it was, we produce ice cream from Happy Cows, and then right below it, it explains it. And so it's right there for the consumer to read, and the reasonable consumer should understand like the contents that are put in front of them. And it's really unreasonable just to cherry pick statements that are made. And you have to, again, sort of like it's the other side of the coin. The courts are considering the context and how people are purchasing, just as they're considering the context of how the statements are presented and what is presented as well. So that, again, is helpful. Sort of the helpful trend is that context really matters, and it's both the labeling / advertising and the consumer user experience.
Yeah, and Frank, I just wanted to point out a couple of things there real quick. One is that this is a really important point that you'll see later, is that, and Frank mentioned it about cherry picking, that it's important, and I think at one point this was not really the case, but courts have almost universally now said that you have to look at the entire contents of the packaging. You can't just pick one particular thing and say, oh, I'm only going to look at that. Now, there's a couple of maybe exceptions to that we'll talk about, but generally that's true. Now, the other thing I wanted to say is, these last few slides have been sort of the greatest hits These are the ones that, they're fun. They have, some of them have sort of snarky comments from judges. They are frankly some of the more ridiculous claims that have been brought forth that are, have been dismissed, which is good. But I don't want to paint too rosy a picture, because there have been plenty of similar type cases that have, there may be a little, one click more plausible, that have passed the motion to dismiss standard. So I just want to make that clear that, while it's fun to talk about some of these ones we just talked about, they're not necessarily, by no means does it exemplify that all courts are dismissing these claims. Go ahead, Frank.
And going off that point, and there are a couple here that we've listed where it's they're somewhat more straightforward claims. And as Trent mentioned, the greatest hits are sort of the more ridiculous ones. But these are ones where courts have said, no, like it is plausible, and you can move forward. The Dannon versus Chobani case, it mentions a parent walking down the dairy aisle trying with a child or two, isn't going to necessarily read the label. Again, like you can't look at it and read the full label and understand all of this information, because the kids are distracting. I walk through the aisles with my kids, and I feel like I spend more time trying to take things out of the cart that they're grabbing and trying to put in, rather than actually getting what we need. So I can sympathize with that view in some respects. And so again, you're having to consider the full context of everything, and so courts are not necessarily saying that uniformly, like dismissing these claims, that they do go forward, and it's usually when they're a little more when the claims are a little less of the hyperbolic ones, like the happy cows and that sort of stuff. And with that, I'll turn it back over to Trent.
Thanks, Frank. So here we're going to go into some of the most significant cases of the last few years. And these are circuit court cases, and I think they're the ones that until, there's a couple of even more recent cases we're going to talk about that has sort of changed things, but we wanted to provide you the context going into there about where things have been. And the first one to note is this Williams v. Gerber Products case from 2008. Now, that has been the bane of a lot of defense attorneys' existences over the last, 16 years. It involved fruit juice snacks. And on the front of the fruit juice snack packages, it contained pictures of fruit. Now, you may ask, what kind of fruit? Well, oranges, peaches, strawberries, and cherries, because it would be boring just to have one kind of fruit. But they were fruit. And the claim was, well, the product did not contain any juice from oranges, peaches, strawberries, or cherries. Instead, it contained juice from just white grapes, so white grape juice. And the claim was then that this was deceptive. And the defendant's counsel argued, well, geez, if you just look at the ingredient list, it tells you what's in there, and it says white grape juice. Doesn't say oranges, cherries, strawberries, or cherries. All you had to do is flip the package over. And the Ninth Circuit here said that reasonable consumers should not be expected to look beyond misleading representations on the front of the box to discover the truth from the ingredient list in small print on the side of the box or on the back of the box, as the case may be. And where packaging pictured a number of different fruits, it potentially suggested falsely that those fruits or their juices were included. Now, this was modified over the years a little bit, and to where, after maybe a decade or so, the Ninth Circuit said, well, if the front package is ambiguous, then it is okay to look at the back of the package or the side of the package, but it has to be ambiguous. And that was the way that they tried to move away from Williams a little bit, but still keep it as good law. and it remains good law, but it has definitely been weakened, and we're going to talk about that. The other case I want to talk about here is the Mantekas case, which is the Second Circuit case out of 2018. Now, if you're looking at sort of the development of the case law, you have sort of three big um, uh, places or courts where this is happening. The first is obviously the Ninth Circuit, the district courts in the Ninth Circuit, and then obviously the Ninth Circuit itself. Then you have the Second Circuit, Southern District of New York, Eastern District of New York, going up to the Second Circuit, and then you have the Seventh Circuit, so Northern District of Illinois. That's where you've seen most of these. You'll occasionally see some others. One of the things that we did prior to this webinar is we did a search for reasonable consumer, a reasonable consumer standard in amongst the courts of appeal. And over the last 3 or 4 years, the only courts that have mentioned it in their opinions are the Ninth Circuit and the Second Circuit. So the Mantekas case was an important one, and it involved a product, so crackers, which were labeled as whole grain or made with whole grain. And the allegation was that calling these whole grain was false and misleading in violation of the consumer protection laws. And the court, so the district court dismissed, but the Second Circuit reversed that and said that it could be reasonably read as promising either predominantly whole grain or just some whole grain. And where sort of the real fight came in is that on the front label of the package, it actually said made with 8 grams of whole grain per serving. So it told you explicitly how many grams of whole grain there was. And I think there was a version that was 5 grams. So either 5 grams or 8 grams whole grain per serving. So it told you. But the issue came in is that, the court essentially said, well, let me read you. This is from the decision itself. Defendant contends that a reasonable consumer still would not be deceived by the whole grain claims because the side panel of the packaging discloses further detail about the product's ingredients. Specifically, the nutrition facts panel reveals that a serving size of Cheez-Its is 29 grams. And the list of ingredients names enriched white flour as the first and thus predominant ingredient. But neither of these disclosures cure the deceptive quality of the whole grain claims as alleged by plaintiffs. First, the specification that 29 grams is the total weight of a serving does not adequately dispel the inference communicated by the front of the package that the grain in whole grain crackers is predominantly whole grain, because it does not tell what part of the 29 gram total weight is grain of any kind. Such serving size information clarifies the amount of whole grain as a proportion of total serving, but does not indicate the ratio of whole grain to white flour. And then it goes on to say, we cannot conclude that these disclosures render plaintiff's allegations of deception implausible. Reasonable consumers should not be expected to look beyond misleading representations on the front of the box to discover the truth from the ingredient list in small print on the side of the box. Now, that may sound familiar, and the reason it sounds familiar is because that's from the Williams case, and that's the citation that is made here. So that's how the Mantekas case came out in the Second Circuit. We then had the Bell case from the Seventh Circuit, and it involved 100% grated Parmesan cheese. Now, I want to flag this 100% because we're going to come back to that particular claim here in a moment. And in this particular case, the plaintiffs alleged they were misled by the front labels stating 100% grated Parmesan cheese. And ultimately, the district court dismissed this case. And it was actually an MDL, so it was something that all of us were following closely. And the claim was that that is misleading because the products contain between 4 and 9% added cellulose powder and potassium sorbate. The court found that although the presence of these other ingredients was readily apparent to any consumer who took the time to read the fine print, who sort of flipped it over and looked at the ingredient list, And although the context of the entire packaging remains relevant, an accurate fine print list of ingredients does not foreclose, as a matter of law, a claim that an ambiguous front label deceives reasonable consumers. It also noted that many reasonable consumers do not instinctively parse every front label or read every back label before placing groceries in their carts. And as a result, it reversed it. So this is 2020, 2 years after Menteithus. And then we have Moore v. Trader Joe's, which was the next year, 2021. And this also involved a 100% claim. And this one was surprising and is really the game changer. This is the one that changed everything. And so I want to flag that up front. And you know, we're going to be talking about the ramifications of this particular decision, but I want to spend just a minute or two talking about what exactly happened here. And it's all the more sort of surprising in that it came from the Ninth Circuit, which, you know, there's this sense that it's, you know, historically that it's been very liberal, and I think there's some truth to that. And you know, anti-defendant and pro-plaintiff, but that has changed in recent years. And you may recall that in the last Republican presidency that there were a number of nominees to the Ninth Circuit, and that has, I think, changed the balance of power to a certain degree. And it is no longer viewed, depending on the panel you get, as pro-plaintiff as it used to be. So this particular case involved 100% New Zealand Manuka honey. And the court found that it was not likely to deceive a reasonable consumer into believing that the product contained only honey from the Manuka flower. The court reasoned that there was some ambiguity, so that this is how the Ninth Circuit, or this particular panel, reasoned getting around that Williams decision. It said, oh, there's some ambiguity. It's not clear what is meant by 100% New Zealand Manuka honey. It could mean that the Manuka flower was the only source of the honey, or that the Manuka honey flower was the primary source of the honey, or that 100% of the honey was from New Zealand, given that it says 100% New Zealand Manuka honey as opposed to 100% Manuka honey from New Zealand. And because of this ambiguity, the court said that reasonable consumers would necessarily require more information before they could reasonably conclude Trader Joe's label promised a honey that was 100% derived from a single floral source. And that additional information could be something on the rest of the packaging, such as the ingredient list, could be the price of the product, or in the context of honey, general knowledge about how honey is made. And anyone who knows anything about Manuka honey knows that it's super expensive. At least real Manuka honey is. And I actually bought some recently. And, you know, I actually did a lot of research on my phone in the grocery store to see, like, how good is this Manuka honey? Is it pure? Is it, you know, got the right rating, that kind of thing. And the court went on to say, while the reasonable consumer is not expected to be an expert in honey production, the reasonable consumer should know that beekeepers cannot force bees to gather honey from only certain types of flowers. Now, you know, I'm going to ask Frank this question because, you know, I have to confess, I don't know a whole lot about bees and honey, and I'm not sure that I had ever thought about that particular issue before. But Frank, did you know that you know, beekeepers cannot force bees to gather honey from only certain types of flowers?
I did not know that, and my wife's aunt is a beekeeper, and she talks about it, and I usually just zone out. So really, that's on me. But that was not something that I knew.
Yeah, so I think one of the striking things about this particular case is it really did, you know, put more responsibility on the consumer to do additional research. And we can debate whether that's a good thing or a bad thing. But, you know, it unquestionably did that to a much greater extent than I think we've seen in a lot of other cases. And ultimately, the court agreed with the district court's conclusion that other available information about Trader Joe's Manuka honey would dissuade a reasonable consumer from thinking that the product was derived only from Manuka flower nectar. So, more big, important decision from the Ninth Circuit. Now, we're going to talk about what that means since that has come out. And let's start with this question. Who is the reasonable consumer? We've talked about what the reasonable consumer standard is, but I want to spend a little time on who it is. And notice I said who, because I want to get more precise, not just identify the traits of a reasonable consumer. I want the actual name of the reasonable consumer. And that's what we're going to do here today using The Simpsons. Now, I don't think I mentioned who my favorite Simpsons character is. I would probably say Flanders, the next door neighbor with the mustache, who constantly has hijinks going on with Homer, or Mr. Burns. I do love Mr. Burns, not because I necessarily identify with him, but he's a funny guy. Okay, so you may recall we were talking earlier about some of the traits of the ordinary consumer from the California cases and the prior standard, and we said someone who's not typically exceptionally acute or sophisticated, someone who is not wary and suspicious of advertising claims. So someone who, frankly, is a bit of a dimwit. And, in terms of who that might be from The Simpsons, well, I think it's pretty clear that Homer Simpson would fit the bill. And of course, Homer, going back to what I said earlier about, being the first time you've ever gone in the grocery store and whether that's a reasonable consumer or not, Homer doesn't even shop. So of course he's going to have trouble if he went to the grocery store and was presented with Manuka honey. He might be like, oh my gosh, that's fantastic, 100%, and buy it. But he would not be the typical consumer of that. And you can imagine that episode of The Simpsons, which sort of writes itself. Homer goes to the grocery store for the first time ever and buys $35 Manuka honey. Or it could even be a different Simpsons character. And this is a bit more of a deep cut, but it could be Cletus Spuckler, who's considered even more of a dimwit than Homer, which is saying something. And so, this is who, and Frank, I don't want to hear any comparisons of Cletus to me, so just back off. So Homer and Cletus would be sort of what I think a lot of courts viewed the reasonable consumer as prior to the Moore case. All right, so let's talk about what the reasonable consumer is now after the Moore case. And so there's a great decision that came out, and I frankly think there's too few of these kinds of decisions out there, where a court, rather than just sort of, cites to a case and doesn't really go into depth in discussing it, then says, here's the holding. But every once in a while, you get a court who's like, you know what, I'm going to dig in on these issues, and I'm really going to do, I guess, what you would call in Westlaw speak as an examination of a case or a topic. And that's what happened in this La Barbera v. Ole Mexican Foods case from 2023, about a year ago. And I think it's notable what the court said about Moore. So, and let's take a quick look. So Moore imagines a reasonable consumer who is intelligent, someone capable of analyzing different pieces of information, engaging in logical reasoning, and sort of makes it to where that is not Homer Simpson, and drawing contextual inferences from a product and its packaging. She is diligent. Now I want to flag there the she, because that is not a coincidence. I can promise you that they are using she as opposed to he. She is diligent, for she does not just view one phrase or image in isolation, but looks at the entirety of the packaging together. She takes into account all of the information available to her in the context in which that information is provided and used. And this is in some ways the most important part of this, she appears to exhibit some skepticism about the representations made to her. So it's not someone who's going into the grocery store for the first time. It's your the person, like a lot of us are, who are inundated with ads all day, every day, with their phone, TV, radio, whatever. And we have to constantly sort of sift what's real, what's not, what's a scam, even with our emails. Is this a scam email? Is this not a scam email? So it's something that we're sort of doing all day, every day anyway. Exhibit some skepticism about the representations made to her by products advertising, aware that corporations attempting to sell items are conveying information to a given end and in a certain light. She does not expect advertisers to lie to her, nor should any consumer do so, but she understands nuance and context, and that when making her purchase decisions, all representations made by a seller are designed to sell. In other words, you're expecting that the reasonable consumer is expecting a certain amount of spin, and they take that spin, they take it with a grain of salt. That's what this case is saying that Moore said. And I think this is a very accurate description of the holding in Moore. It goes on to say that central to Moore's analysis are two additional premises: that reasonable consumers generally know a little bit about that product, at least more than a random person on the street who may have no interest in the product or given it any thought. And if a consumer cares about any particular quality in a product, she's willing to spend a few seconds reading a product's packaging to see if it answers her question. And so then there's an explanation or discussion about honey. It says the reasonable consumer in the market for honey, particularly Manuka honey, is not just the amalgamated average American. She is a reasonable honey customer. And I think that's super important because Homer Simpson walking in the store, never having been exposed to Manuka honey, is one thing. But if you're defining the reasonable consumer as someone who knows a little bit about honey, it changes things. And this particular decision, La Barbera, says that the reasonable honey customer is someone who has thought a little bit about the foraging nature of bees, and therefore would know that it is impossible to produce honey that is derived exclusively from a single floral source. Now, Frank, that may mean that you're not the reasonable honey customer, given what you told me earlier, but that's okay. There's no shame in that. And it says the bottom line is this: the reasonable consumer, under Moore, does not approach purchasing decisions with a professorial genius or inclination toward exhaustive research, but she is also not a chump, too doltish or careless to engage in a simple analysis. And I think that this judge, when he was writing this particular opinion, definitely had Homer Simpson in mind when saying that, the reasonable consumer is not a chump. So that's what this court said. I think it's a very good analysis of what the reasonable consumer, and if you haven't read or heard of that case, I really urge you to take a look at it because I think it's very helpful. And so after that, let's see. After that, who is the reasonable consumer now? So I think one answer is it's not Homer Simpson's, it's Marge Simpson. She's no fool. She knows what she's doing in the grocery store. And if she sees Manuka honey on the shelf, she isn't going to blindly buy it based on one claim. She's going to look into it a little bit. She may even pull out her phone and do some research and say, oh, geez, well, this rating means this. And if it's +6, then that's not as good as if it's +15. And there are these ratings for Manuka honey because I distinctly recall looking into them. So that's one way to think about things, is that it used to be Homer. Now it is Marge, or perhaps even Lisa Simpson. And anyone who has watched The Simpsons sort of knows that Lisa is in many ways the smartest and most sophisticated character on The Simpsons. Just a preternaturally gifted student, constantly questioning things, and I think that could be another answer for who the reasonable consumer is, setting aside the fact that she is, I don't know how old she is in The Simpsons, maybe 12, something like that. But she would not have any issue with being deceived by Manuka honey. And so there you have it. So we have attempted to concretize the reasonable consumer down to two names, and we have done that: Marge or Lisa Simpson. So I urge you, the next time that you are arguing a motion to dismiss in front of a federal judge and you get asked by the judge, who is the reasonable consumer? And that is a question that they like to ask. You have your answer. You just say Marge Simpson, Your Honor, and I'm sure you won't get into any trouble whatsoever. On second thought, maybe don't mention Marge Simpson, but be thinking about Marge in your head. So one other thing I wanted to do, and then I'm going to turn it back over to Frank here, is I wanted to give you a recent example of two cases that are very similar, decided by the same court, same panel of the same court, and show you how they dealt with the reasonable consumer standard. And it's rare, you know, often you have different products, right? You have different courts deciding on different products, and it's hard, it's apples and oranges. It's hard to really get a beat on things. And so we found two cases decided last August by the Ninth Circuit. And it's the same panel of judges decided 4 days apart, analyzing the same claim on near identical products, and it reached opposite results. And these are the products here. So one is wet ones. The other is an antibacterial wet ones, to be clear. And the other one is hand sanitizer. And the claim at issue for both was kills 99.99% of germs. So let's look at what happened here. So one of these was decided on August 7th, 2023. And it reversed a grant of a motion to dismiss and reinstated the case here. And this is the wet ones. And it said it gave one of the reasons why was that the ordinary reasonable consumer has very little scientific background. Now, you know, that arguably flies in the face of Moore or La Barbera to a certain extent, but maybe it doesn't. And then it also held here at the end that a reasonable consumer would likely presume that the hand wipes are intended only for use on human hands, but it is not necessarily clear that such consumers are capable of discerning which pathogens are typically prevented by ensuring one's hands are clean. All right, so that's a bit of a word salad. I'm not sure I can even wrap my head around that particular sentence. And I would submit that this particular case is really treating the reasonable consumer as a Homer Simpson. Now let's contrast that with the Robles case, which was decided August 3rd, just 4 days before. And like I said, this was the exact same panel, the exact same judges. And it involved the Purell hand sanitizer, and it kills more than 99.9% of germs. But, and I think this may explain the difference in outcome, it included an asterisk or a disclaimer directing consumers to the back of the label, and it states that it kills 99.99% of most common germs that may cause illness. Now, I'll be honest with you, I'm not sure that particular disclaimer really says a whole lot different than what's on the front, but it's there. And I think that matters to this particular court. And so, you know, this seems like more of treating the reasonable consumer as a Marge or Lisa. I wish that I had some kind of neat reason for the distinction here and what this particular lesson is here, but I really don't. I think it maybe exemplifies that courts are still struggling with where to draw the line on the reasonable consumer standard, even after Moore and some of these other decisions we've looked at. But there are some things that we can point to that help and help put companies within the reasonable consumer standard and, you know, trying to avoid, being held liable under the the reasonable consumer standard for deception. So we're going to talk a little bit more about that. We're running out of time, so I'm going to ask Frank to, you know, go through some additional things here quickly in the next, 7 to 8 minutes, and then we're going to wrap up with trends and takeaways after that.
Thanks, Trent. I will respect your wishes not to compare you to Cletus. And you mentioned Mr. Burns, and I won't compare you to him, but at least you remember my name, which is nice. Um, so, uh, so, as Trent mentioned, the Second Circuit in New York is another big area where these cases are brought. And I just want to highlight real quickly the McCracken case. It related to excessive fees, deceptive fees, and really the court boiled down plaintiffs' arguments to saying that they were deceived by the fees because they didn't know that the company was using the profits from the fees to then offset losses elsewhere, which the court kind of rejected out of hand and was like the reasonable consumer isn't concerned with the company's profit margin or a company's or how a company spends their profits. A reasonable consumer cares about the price and the value they receive, and so again, that highlights one of the sort of um, more extreme pieces. But I would point out the Richardson case. It related to a reef-friendly claim on sunscreen, and essentially the package said that it was leaf-friendly, and it didn't contain oxybenzone or oxynoxate. Um, but it said that it was incomplete because it didn't mention other ingredients that were not reef friendly. But also, this quote sort of backs up the Libera case that Trent was talking about is like a reasonable consumer cannot be expected to know the universe of chemicals harmful to coral reefs such that she could discern from an ingredient list describing the product's contents in scientific terminology that in fact it is reef friendly. And so it seems to me that there's somewhat of a sliding scale, like depending on what the statement is or the advertisement is. You know, the iced coffee example, like it's sort of basic, straightforward. But here, the sunscreen was reef friendly, and then it gives a bunch of scientific information, and reasonable consumers aren't necessarily going to know the science behind it. She's not a scientist. She's not a marine biologist that might be able to do that. And just to correct Trent saying that he mentioned that it was just the Second, Ninth, and Seventh Circuits in recent years talking about the reasonable consumer. I was able to find two, one in one in the 10th Circuit and one out of the 11th Circuit. So other courts are addressing it. This Renfro case related to dog food labeling and claims that they use fresh and regional ingredients. And so the label on the back actually said, here's what's fresh, here's what's not, and here's where it comes from the region, from what regions. And so a reasonable consumer that reads the back has it laid out for them what is fresh and what is regional. So you can't be deceived. But the reasonable consumer standard that we've been talking about isn't everywhere. The 11th Circuit in this Marquez case noted that the Washington Consumer Protection Act looks at it from the least sophisticated consumer perspective, the Homer or the Cletus of the bunch. But again, it's looking at it in sort of the same way that the disclosures related to this Amazon shipping, Amazon had provided enhanced shipping related to COVID, but the website says that it would be as available, and it changed its policy. And the court said, they're not hiding the ball, and so that's even not going to deceive the least sophisticated consumer. The quote of "perfection is not the standard" is one that's good, I think, because even where you're looking at it from the least sophisticated consumer perspective, the court doesn't expect perfection. And if you're not hiding the ball and being what is perceived to be as straight up with the consumers, then you're still fine. Um, then we have a handful of other cases, but just in the interest of time, um, just we'll mention briefly that the reasonable consumer isn't necessarily just um, in the context of these consumer class actions. The FTC uses reference to the reasonable consumer. So does the Lanham Act related to confusion. And then also in the Fair Debt Collection Practices Act also references consumer, reasonable consumer. So trends and takeaways, the reasonable consumer is smarter, more sophisticated, and more willing to sort of look into the transaction and look into the product before purchasing it. And hopefully that will lead to the trend in more cases being dismissed at the motion to dismiss stage. But even so, the disclosures or advertisements should be clear and fulsome based on what a consumer's common experience might be. And again, the context includes both the label and the disclosures, or the advertisement and the disclosures, and what a consumer experience is, or how or how the user is interacting with the transaction.
Yeah, and I just want to add on to that. I mean, we were sort of joking about the Ninth Circuit panel, but I really do think that the distinction between those two cases that I mentioned earlier really does come down to that asterisk or disclaimer. And it mattered to that court that, that was something that was included in there. And so including disclaimers, I think, is one way to short circuit some of these types of claims going forward. I mean, obviously helps to be able to know that Moore and La Barbera and those types of cases are out there that you can cite to. And you should, but it also helps on the front end to try to avoid some of those claims in the first place, to have an asterisk that you can point to say, look, we include the information. And why is that? Because even in the cases that didn't necessarily go the defendant's way, like Manticus, even Manticus is saying that in determining whether a reasonable consumer would have been misled by a particular advertisement, context is crucial. We therefore consider the challenged advertisement as a whole, including disclaimers and qualifying language. And I think it's particularly helpful to have the asterisk where, it's not per se on the front label, but anyone who's looking at just the front label will see the asterisk and know that they really should look at the back label for some additional information. And you see that Manticus quotes or cites to Fink, or quotes Fink, as well as the Freeman case. Just so happens that the Bell case, the Seventh Circuit case we mentioned earlier involving grated Parmesan cheese, does the same thing. And it also said, we said that we stand by the general principle that deceptive advertising claims should take into account all the information available to consumers in the context in which that information is provided and used. And it once again cited to Fink, which talked about the presence of a disclaimer or similar clarifying language may defeat a claim of deception. And then the Freeman case, which affirmed dismissal of a challenge to sweepstakes mailer, where the mailer explicitly said plaintiff would win only if he had the winning number. So I think that is where we're going to end this. We have some additional slides in our materials that talk about surveys, consumer surveys, and gets really into the weeds there. And by all means, we would love for you to look at those. And if you have questions or comments or want to discuss those, give us a call. And the same holds true for everything else as well. If you find these issues interesting, you want to talk about them, by all means, you should feel free to reach out to Frank or myself, and we'll be happy to chat with you or try to answer your questions. And we very much appreciate you all attending here today, and we hope this has been helpful, and we hope that you'll consider attending additional of these Brown Bag Lunch series presentations that we do in the future. So thanks so much. And with that, I'm going to ask Sean to end the webinar now.